Welcome to this very special edition of the KJ Masterclass Live, the show which ensures that you profit from your time spent here with experts, either through the industry insights, information, or simply learning from them. And today we have Nick Guinn, trademark and patent attorney, live from the USA. Welcome to the show, Nick.
Hello, Ajay. Thank you so much for having me. I'm so excited to be here.
Welcome. Welcome to the show. Welcome to India. Welcome to all the places that this podcast is going right now and will certainly be consumed by a lot of people across the world. And I'm sure they will gain from the insights and understanding of the legal knowledge that you'll give, especially on trademark and patent. So, Nick, straight to the basics. You assist clients in all aspects of intellectual property. If we talk about from a layman's perspective, what exactly is intellectual property in today's time? Earlier, was it different, and now is it changing with so many things happening online?
Well, Ajay, of course, intellectual property from a layman's perspective is the area of law that is intended to promote and protect ideas. And it has evolved over time. When the U.S. Constitution, for example, was enacted or was drafted 200 plus years ago, one of the provisions was to promote and encourage the useful arts, inventions, and the creative arts, works of art, and those are protected through patents and copyrights. And over time, other intellectual property forms have developed to account for the needs of our economies, trade secrets to protect proprietary ideas that businesses don't necessarily want to share with their competitors or the public, but benefit their business, and trademarks, which are source identifiers, names, logos, taglines. As a business, you don't necessarily want your competitors or third parties to weaken your brand. You want to stand out. You want your brand to represent you. And so trademark law, interestingly, not only protects brands, but also protects consumers, so that consumers know that when they purchase something from KFC or McDonald's, they know what they're getting.
Okay, okay. And how do these companies, because we'll be talking about how can companies or anyone else use trademarks to protect and build their brand. Now, their product or services, they go to a lot of places across the world sometimes. How does one ensure, what are the tools available for a brand, small brand, an individual, and a bigger brand? Bigger brand has money, so they can hire good, they can get good legal help. What about a general person who would who has something important? They don't know, or sometimes know that it is very important, but it can be that suddenly they find that their rights, which they even don't know at that point in time, but later somebody else says this, your right has been breached in terms of your patent, not patent, but in terms of whatever intellectual property that you hold. What would you advise people in today's time, either in terms of small businesses, services, and even smaller brands who do not have the wherewithal of a big firm, who can keep a watch on what's happening with their trademark or their brand name?
Well, there's a lot there, Ajay. I think one of the first and foremost steps is for brand owners to consciously think about the brands that they're going to develop and invest in. It really is a sad day, and it happens every day, to see brand owners who have spent a lot of time, money, blood, sweat, and tears building a brand, only to receive a cease and desist letter or a lawsuit from another business telling them you need to stop using that name or logo, etc. When in fact, a lot of that could have been prevented had the brand owner done some searching at the very beginning. When it comes to that searching, often using a search engine like Google, getting on social media and seeing what businesses are putting out there, and even performing some searching at the relevant trademark database. If you're in the United States, that's the U.S. Patent and Trademark Office, and seeing, are there identical marks? And for similar goods and services, and maybe not even just identical marks, but marks that are similar. If someone started selling tennis shoes and they called them Noke, Noke, I suspect that Nike probably would take issue with that. So doing some searching, and if as a brand owner it sounds funny or just doesn't seem, if you suspect there's going to be a problem, err on the side of caution more often than not. And if you have the resources, consult with an attorney, even if it's 30 minutes to an hour, just to save yourself from that burden, that expense, that hassle from having to change. Now, assuming that you're already operating and using a brand, it's important to audit and assess what is your brand, what are the marks that you're already using. What is your name, what is your logo, what taglines are you using, and to really perform this kind of deep dive audit in terms of what do you have, and from there assess, am I using my marks consistently? Does my mark have a hyphen? If it's a compound word, does it have a hyphen in some instances, but maybe it's two separate words in another? Maybe it's a combined word in an even different instance. That could be problematic. So consistency is good. And then checking to see, are other people using the mark? And just like you search to see, am I stepping on anyone else's toes? You should check to see, is anyone stepping on my toes? And it's a lot easier to ask someone to stop using a mark early in their journey, as opposed when they've invested very little, as opposed to an established business of several years that's put in a lot of time, money, and other resources.
Right. Nick, you know about this part of the law very well. You are you are owner of Gunn, Lee and Cave PC. And then you have also seen things very closely as a law clerk to Chief United States District Judge Fred Biery. Now, seeing the law so closely, how do you see in terms of, say, application of law, for example? And I don't know if these are apt examples, but a lot of people, you see, they register something and they say this is, registered. They put that R thing.
Mm-hmm.
There is it's almost like a tag, keyword, 2-3 words at the same time. What does it mean? That they own those words, nobody else can use them? How does this? Because they are all part of this alphabet and those 3 words. So how does it work? I cannot use them. What does it mean? What do they own? What do they not own? Firstly, on that, because that's what a common person generally deals with.
Sure.
Then, in terms of infringement, a person who is a company or brand existing in the US, and it happens quite often, but somebody in any corner of the world, perhaps in India, they pick up something from that, and with time, this name also becomes famous, and then the US company wakes up, or it can be other ways, and then there is a fight that you have copied, you have infringed on our rights, it's our intellectual property, and they say, I did not know, I just, there is, and I only drew an inspiration. So how does this all work in terms of registered brand name or registered? They use the word registered, and in terms of protection of their intellectual property rights across different countries.
So I must confess that, different jurisdictions, i.e. different countries, have different nuances to how they treat trademark law. And a lot of that stems from whether their laws are based on English common law. India and the United States are both originally grounded in English common law or have a lot of ties to it. So there's certainly some similarities. A lot of other countries stems from civil law. And because trademark is a property right, that has some pretty big impacts. But there's definitely some commonalities and themes that we see across countries in terms of trademark rights established from use and trademark rights established from registration. And the two in the United States complement each other, and there's layers to it. So in the United States, and other countries do kind of follow suit here, is as soon as you use a trademark, whether that's a name, a logo, a tagline, or any other source identifier that distinguishes your business from someone else's, you have common law rights. And so by virtue of using the mark, you have trademark rights associated with that mark. And those rights are fairly narrow geographically. Where are you using the mark? Or, are you selling the goods or services out of your office in a small town? Okay, well, your rights are probably limited to that small town. But if you sell products across the country, well, then your rights probably extend further. And your rights also limited to those goods and services. Now, you can enhance your rights by registering your trademark with the relevant jurisdiction. So in the United States, you would register your trademarks with the U.S. Patent and Trademark Office, and that gives you nationwide rights. There's some nuances there, and I'll spare those details. But generally speaking, you can have common law rights and you can have nationwide rights through registration. In the United States, you cannot use the circle R until you have a federal registration with the USPTO.
Okay.
Can't do it. If you use it before that, you could find yourself in trouble. But as soon as you have common law rights, which is as soon as you start using your trademark, putting it out there in the marketplace, you can put the TM next to your name or logo. And I can't recall if TM is used in India, but it's definitely used in the United States. And you can do that from the start. As far as your question, Ajay, about whether what rights does the registration give you? Do you have a monopoly over those rights? Your rights generally, you have exclusive rights with respect to your mark and the goods and services that you've identified in your trademark application. Now, one thing a lot of people don't realize is that when you file a trademark application, you have to tell the Trademark Office, what are your goods and services? Are you selling cereal? Are you selling tennis shoes? Are you selling paint? Whatever it is, you've got to list the goods. And sometimes it's a long list. Sometimes it's one thing. And if in the United States, you can file an application indicating, I am using the trademark. I've been using it in connection with these goods and services for X number of years, going back to this date. And you provide proof that you're selling those goods and services. Maybe it's a screenshot from your website, a picture of your product and its packaging. You have to provide proof. The US also has an option of filing on an intent to use basis. You say, I'm not using the trademark yet, or I'm not using in connection with all these goods and services, but I will. And the Trademark Office will begin to review your application. And at some point in the next few years, you need to submit proof that you have used the trademark. So you can't get the registration without proof of use, unless you're from another country. So let's say you're an Indian business and you are wanting to expand into the United States or want to have trademark rights in the United States, you can file applications in India or another country, obtain trademark rights there, and then subsequently file an application in the United States under other mechanisms and potentially get through registration without demonstrating proof that you've used the mark in the United States. There's international treaties that provide for that, but that's something that's pretty nice for non-US based businesses when expanding into the United States. As far as going back to the question of what would be infringing, the exclusive rights, trademark disputes in the United States and in a lot of other jurisdictions tied to, is there a likelihood of confusion? At the end of the day, as I said, this is a consumer-driven law. We want consumers not to be confused based on the marks. And courts in the United States consider several factors. They consider how similar are the marks. Are they identical, or are they still pretty close? Nike and Nokia, pretty similar. But Nike and Reebok, not very similar. How similar are the goods and services? Tennis shoes and tennis shoes, identical. Tennis shoes and leisure shoes, similar. But tennis shoes and paint, not very similar. And there's several other considerations that go into the analysis. But courts are trying to get an assessment of, are consumers likely to be confused by these two trademarks? And so it can be a pretty involved analysis. If you're concerned about infringing, it's probably a good idea to talk to a trademark attorney, get their opinion, an assessment of the situation. And I will say, unfortunately, because litigation, especially in the United States, is so costly, it pays to make wise decisions on the front end. And often parties compromise early in this dispute because of the uncertainty and because of the cost of litigation.
Right, right, Nick. Now let's look at the online stuff that's happening. Now, when we talk of identity theft, then it's somebody has, used my name, my anything else, and we consider that as a bad thing that somebody has stolen my identity. And there are laws. How much they get implemented, nobody knows, because different countries, again, it will work very differently, and there is this anonymity which a lot of these cyber uh, uh, delinquents, if I may use it, or criminals, whatever you may want to call them, they use it. But when it comes to brands, anybody can use there is misrepresentation, if we may call it. And then that happens. By the time you figure out, those people have already made some quick money, and then they keep on. Those people who are not, who are there to keep changing from one thing to another. How do you make sure that people are not, because a lot of businesses are happening online, Nick, and your brand identity may get twisted, get hurt, you may lose business by the time you even come to know of the many, many countries that we have in the world. So how do I protect my brand? Almost like a brand identity theft, it happens with a brand. Secondly, what are the ways for a smaller brand to make sure that they are growing and somebody else is not using it in a manner so that later on they are able to arm twist this company which perhaps grows to a bigger level? How do you do that?
So when it comes to trademark infringement, there's several varieties, but at a high level, you've kind of touched on two different ones. You have your, I guess, probably more familiar trademark infringement where you have two businesses, the senior user, the first one that started using the trademark, and then a second brand, the junior user, the one who came along second. And maybe the junior user didn't even know about the senior user, or maybe they knew about the senior user but didn't think there would be a problem. There still can be trademark infringement. In the United States, intent is not a requirement for infringement. Now, if the junior user intended to confuse or create problems, that can be some bad facts for the junior user. But the fact that there's confusion and the likelihood of confusion, that unto itself can be enough. And that's one thing. On the other hand, there's counterfeiting, and counterfeiting is a huge global problem. I'm very active with the International Trademark Association, and one of our missions is to combat counterfeiting, and we have the Unreal campaign to educate high schoolers, et cetera, and I digress. But counterfeiting really takes into account the situation where you have the really naughty or bad actors who are selling the fake purses, fake pharmaceuticals, fake makeup, et cetera, trying to replicate and rip off the senior user. And the laws for counterfeiting are a little bit different than your kind of more familiar trademark infringement. The tooth of law, or the teeth, are sharper to try to combat counterfeiting. But as for your question about what do you do about it, there's several things. So large, established, big businesses have teams of people who spend all their time searching, looking out for these problems. Their brands are too big and important to not spend those resources. Smaller brands, from small startups to a little bit more established, still have options. They may not have a full-time staff person or full-time staff people going through that exercise, but they can still devote some resources. They can, maybe make a point of once a month, once a week, whatever works for them. Get on the web, search social media, search engines like Google or Yahoo, and see, type in your name or similar spellings to see what else is popping up. If you find that there's another business that's similar, take note of it and dig deeper. Other things that exist are search firms. There's companies that you can pay or watch services that will monitor for you, and if they think that there's a mark that's particularly similar or confusing coming up, they'll ping you and they'll say, hey, we detected this third party out there. You may want to do something about it. And then what I find happens the most for my smaller business clients is they're either on the web doing work on their website or social media, or looking at how their profiles appear, or a friend or customer is looking for them and inadvertently detects this third party. Often it's not even an intentional, let me go see who's infringing, but it's just in the day-to-day business, someone reports and says, hey, are you aware of this third party that's out there creating problems?
Right, Nick. To understand this whole thing better, Nick, what type of cases that you people get at your law firm?
So we represent clients in a wide variety of industries. I in particular work with a lot of online businesses, a lot of food and beverage businesses, including restaurants and food manufacturers, and a lot of financial institutions. A situation that would be very common for me to see would be for a winery or a brewery to maybe they've protected their trademarks, or maybe they haven't. Maybe they've never thought about trademarks in the past, but they have common law rights because they've used the mark. And one of their friends contacts them and says, hey, I was going to place an order online or look for directions to your winery, but I noticed that that there's another business down the road, or there's another business in the city three towns over. Do you have a second location, or where can I find you? Which address is yours? And that starts to make them realize maybe there's someone else out there. They investigate, they contact me and they say either, Nick, thank you for helping us protect our trademarks years ago. We need to enforce now. Or they say, Nick, we've never met, but I have a problem. Can you help me with it? And at that point, we consider whether it makes sense to do anything. Sometimes there's nothing to do. Sometimes we start with what's called the cease and desist letter, where we contact the other side and say, hey, we've noticed what you've been up to. Here's what you need to know about my client. If you didn't already, my client's well known. My client has built this brand, and we need you to stop. That's the high level. And hopefully they stop. Sometimes it works, and sometimes they say, no, we're going to keep doing what we're doing. And if they don't stop, the client and I have to consider, does it make sense to file a lawsuit? In the United States, 99% of lawsuits settle before they ever get to trial. But even cases that don't go very far can get expensive. And if they go to trial, they get very expensive. And so the client has to make a cost-benefit decision as to that. And then we go from there. And we may pursue litigation. One point a moment ago, in terms of what can they do to help their brand, is not all trademarks are created equally. We have very, very weak marks, that generic terms that aren't even protectable. So if I put a bag of salt on my desk and it said salt, it's generic. It doesn't tell you where it came from. It just tells you what it is. But there's also fanciful trademarks on the other end of the spectrum, made up words like Exxon, Kodak, Polaroid, or I suppose in India, Exxon is probably known as Esso, if I'm right about that. Made up words. Those are the best kinds of trademarks. And it is far easier to enforce your rights in a strong, distinctive trademark than a generic or highly descriptive trademark.
Right. Talking of, generic names or brands, then even Alexa is a very generic name. How come Amazon will be able to protect it if I say do not have a good experience with Amazon or Alexa as such, and I keep on writing about it online, Alexa broke my heart. Mm-hmm. And obviously people will understand what I'm trying to mean, but actually I can say about it's a girlfriend that I had, or whatever it is. How does it constitute brand infringement? Because online this thing can actually go a lot of places, and nobody will be able to question me, or can they do that? How does it work where companies start naming their products in terms of generic sense, some generic name? How do you, or maybe hundreds of, can it be a class action suit if say 100 or 200 girls named Alexa file a case against Amazon, or for that matter others? Just
So,
think.
so there's two really interesting issues there, Ajay. One is that when you write the comment about Alexa has broken my heart, that's probably not trademark use. You're just talking about Alexa, whether it's your girlfriend or your wife. Although I'm sure you don't have too many people who've broken your hearts. I bet you're the heartbreaker, Ajay. And so it's not trademark use. Trademarks are source identifiers. They're being used to distinguish a brand. If you just wrote a blog post or something, or a forum comment that said, Alexa broke my heart, you're not indicating, what is the good or service? You're not saying where it came from. Whereas Amazon is affixing Alexa to its device that listens to people and takes orders, plays music, etc. And so Amazon is using Alexa as a trademark. The 100 or 200 women who are named Alexa, I'm not sure that their name of themselves unto itself is not really trademark use. Now, if one of those women opens a business, let's say selling books, and they call it Alexa's Books, all right, now we're talking about trademarks. And then we go back to the analysis of, okay, are people likely to confuse Amazon's Alexa for that device with Alexa's Books? My gut is probably not. However, Amazon did get its start in book sales, so who knows? But the other thing is, as far as the large number of people named Alexa, that trademark kind of spectrum or continuum I described, the terms are not considered in a vacuum. So although salt may be generic when identifying salt, it would be highly distinctive if we were using it to identify toothpaste. Or I guess toothpaste could have salt components to it. If we were selling books, if we said the salt bookstore, all right, well, when the salt bookstore doesn't tell you anything about the books unless it was a bookstore dedicated to salt, books on the topic of salt. But otherwise, salt has nothing to do with books. And so it's a good trademark. In the case of Alexa, there may be lots of Alexas out there, and there may be other businesses named Alexa. But if you hear the name Alexa, does it tell you anything about Amazon's product other than it comes from Amazon because we've made that association? It doesn't. And so that's what makes it a great trademark.
Right, Nick. Now, you say that not all brands are created equally. Mm-hmm. Now, what does it exactly mean? Does the law also consider it that way? And why does it happen? Because I thought that everybody, or even an individual, or even anybody else, are all equal in the eyes of law. What does it mean? And exactly how does law treat these things? Does it actually treat them unequally?
Yes. So, you're right, Ajay, that we're all treated the same under the law. But in trademark law, famous marks like Coca-Cola, Google, Nike, household brands, they get a special tier of trademark treatment. So they are treated more preferentially. But let's take them out of the analysis. When I'm talking about trademark, there's a spectrum of trademarks, and some are better than others. Do each of those brand owners get their fair day in court? Yes, if they're willing to go the distance, they get their fair day in court. But a few minutes ago, I mentioned the several considerations of likelihood of confusion. How similar are the marks? How similar are the goods and services? Another consideration is the senior user's trademark strong and distinctive? Has it been promoted? Do they spend millions of dollars on advertising and promotion, or did they just start? That impacts strength. How distinctive is it? Is it salt for salt, or is it Exxon for oil, or Esso for oil and gas? Very different ends of the spectrum. And when I made the comment a few minutes ago about it benefits to pick a distinctive trademark, when the court performs the analysis of considering whether or not there's a likelihood of confusion. A brand owner who is asserting rights in a distinctive trademark, Google, Nike, those are the famous marks, but the Salt bookstore, that's distinctive. They're going to be treated more favorably, and more of the benefit of the doubt is going to go in their favor than Salt for Salt, or salt flavored taffy, or something along those lines. And the reason being is courts and the law consider that, well, a highly descriptive or generic term is used so widely by businesses and consumers with respect to certain goods and services that it's hard for it to distinguish and serve as a trademark. Whereas a brand owner who's taken the time to grow a brand in a distinctive term, they've gone out of their way to make it stand out, and presumably customers are going to appreciate that distinction.
Right, Nick. Now, let's look at the present scenario with that AI coming in. Earlier, there was this thing called IBM had developed something, so they said maybe it will put out several lawyers out of job. I forget exactly what was the name, but something IBM and all.
We don't need to share the name.
Right. But with ChatGPT now, and like this, the new things are coming in. Recently, some judge in another part of the world, he wrote his judgment, and he put that he has done some part of it by talking to to artificial intelligence.
Mm-hmm.
Now, a lot of people are saying you can get a lot of legal work, your property agreements and different sort of agreements by using AI. How do you see AI in terms of legal work being used? Are you people thinking of doing it? Though there is a lot of concern even for regular work that AI may not be always true, and that a lot of supervision is required about even in general copywriting, forget about legal thing. But I just wanted to understand your perspective, because maybe you won't, but many in the legal profession may start looking at drafting their applications and all that stuff, especially in different parts of the world. How do you look at AI coming in, and especially people from the legal profession?
Sure, and I see this impacting us on probably at least 2 to 3 levels as IP attorneys. I see, issues already emerging with our clients. Their clients come to us and say, "I'm using AI, or I want to use AI with this technology. What can I protect via patent? And in terms of trademarks, how do I protect the brand associated with it?" And so those are issues that we're already confronting. And generally speaking, we already use a lot of the existing law, the existing principles to get us there. The technology may be new, but the law, remains the same in our approaches. I see AI slowly creep into the legal practice in terms of how we interact with other lawyers and courts and governmental agencies. That's one issue. But as far as the law firm, I think different law firms are handling this differently and at different paces. I think there's some law firms that are cutting edge, bleeding edge in terms of AI. Others that are not even sure what that means. I can tell you that while I'm not using it in my practice presently, I anticipate it. I either will in the not too distant future, or I at least will have given it serious consideration and ultimately decided it doesn't work right for me right now. I think as having an ethical duty to clients, I think there's 2 considerations. One, how can I do my job efficiently and effectively for my clients? AI may help with that, but I also owe an ethical duty to make sure that I do my job competently. And I probably can't rely entirely on artificial intelligence to do that. I would think other attorneys would still say, even if AI may prepare a document or perform a task for me, the buck stops with me, and I ultimately need to make the final decision.
Right. Now, you have explained things very, very well, Nick, and I'm sure, but legal stuff is such that you can always keep on learning, and it will still be very less. So that's why it is called a practice.
That's right.
So to learn more about you, I guess you have written a book on this particular subject. If you can tell more about your book, and if you can show us so that people can learn, get that book and buy online.
Oh, of course. Well, let me see if I can find. Oh, wait, here it is. Let me see if I can find it. It is Everything You Always Wanted to Know About Trademarks, the Essential Guide for All Online Businesses. Now, this book, I think a lot of brand owners, regardless of whether they are online businesses, could benefit from. The hypotheticals just tend to be geared towards online businesses. I wrote it this past year. It was a lot of fun, and it's short. It's an easy read. Most people can probably read it in about an hour or two and give a pretty good idea of what trademark law is all about.
Right, right. So how do people buy this book? Where do they buy this book? And second is that how do people who want to know more about you connect with you? How do they do that?
So the book is available on Amazon. If you search for Everything You Always Wanted to Know About Trademarks, you can find it there. Or if you search by my name, Nick Guinn, both of those should work. As far as how people can learn more about me, I have several social media platforms, and I hope you'll include those in the show notes.
Right.
I also have a website. We have a firm site, www.gunn-lee.com. And I also have a personal site, www.nickguinn.com. On that website, there's a lot of content in terms of blog. There's videos that we've put out with tutorials on trademarks, patents, copyrights, among other resources. And one resource I want to share with the audience in particular is the Guinn Guide #1, performing a trademark audit. And so for folks who already have an existing business or already using trademarks, or maybe they have a brand and don't realize they have trademarks, downloading that guide would benefit them in kind of performing that audit and seeing what they have.
Right, Nick. Now, my last question to you, Nick, is that you are a very young lawyer, and you not only do the legal practice, but you also do a lot of good work. You teach others. You also teach, Sunday school, coaching high school basketball. You go to the church. What is it that beyond a general lawyer who's too busy because they have to do so much of work? How do you want to take your life forward as a lawyer? What is it that you want to achieve? What is it that you seek for yourself going forward?
I think, like most people, Ajay, I want to leave the world a better place. I want people to think of me. It's nice if people think of you as smart and competent. That's all good for your professional reputation. But I want people to know that I'm a kind, helpful person, and I try to live a life of service, whether that's in my law practice or my personal life as well.
Wonderful. On this note, it's a wrap on this very special edition of the KJ Masterclass Live. Thank you so much indeed for joining us.
Thank you, Ajay. It's been a pleasure.